What is the difference between the maritime law and the law of the sea? Our prompt answer will be like, there is no difference as there is nothing in common. Maritime law and law of the sea are totally different areas of law. How can we distinguish these two different law areas? It is simple. Pay attention. Maritime law applies exclusively to private individuals and entities. The law of the sea refers to international waters and relations between countries. Let's give some examples. As we advised, maritime law applies exclusively to private individuals and entities. This means that the maritime law applies to relationships which are formed between individuals who are involved in the maritime world, for example between an employer, who can be a shipping company, and his employee. Therefore, let's say that you are a sailor or longshoreman who works for a ship owner. A terrible accident occurs while you are working and you get injured. Then, you can seek for compensation from your employer through the rules of maritime law. The law of the sea, on the other hand, is a body of laws, customs, and international agreements that apply to all nations. Put it in a simple way, the law of the sea governs how nations interact with one another in maritime matters. The principles and the rules were established centuries ago to avoid the wars and conflicts that occurred at the sea. Since the 1400s, the UN Law of Sea endeavors to set boundaries between countries. Years and years pass and finally in 1994 a codified international law was created which through multitudinous changes received the today's form, known as the United Nations Convention on the Law of the Sea, or in an abbreviation form, UNCLOS. So, the United Nations Convention on the Law of the Sea is a convention which was signed between nations in an effort these nations to agree until which point each one of them has sovereignty. In other words, the United Nations Convention on the Law of the Sea sets ocean boundaries between nations through rules, principles, and doctrines.
Let's discuss about some examples. For example, the law of the sea involves issues such as the jurisdiction over coastal waters. Jurisdiction over coastal waters answers on how many nautical miles starting from the coast of a country, this country can expand its national sovereignty. For the best understanding of the above, imagine that you have a house. In your house you have absolute sovereignty to do whatever you want, right? Now imagine that you can expand a little bit this absolute sovereignty until some specific meters outside of your house by coming into an agreement for this expansion of your sovereignty with your neighbors. As a householder you can do whatever you want up to the agreed distance. You can implement your house rules, your laws and principles. You can, for instance, to create a beautiful garden and plant your favorite trees, and no one can enter to your garden unless you give your permission. This is the way that the concept of the jurisdiction over coastal waters works. For centuries, each country's territory extended 3 nautical miles into the sea. But UNCLOS set territorial waters at 12 nautical miles or 19.3 kilometers from the coastal line. Up to this point every country enforces its rules and laws and can create a beautiful garden by building anything or extract natural resources. But UNCLOS did not stop there. It permits to every country to place a contiguous zone out to 24 nautical miles from its coast. In the said distance up to 24 nautical miles from their coast, nations can enforce their laws concerning customs, taxation, immigration, and pollution. There are more examples which we can analyze, but the crucial matter right now is to understand the difference between the maritime law and the law of the sea. Therefore, now it is crystal clear that the law of the sea defines relationships between nations, while the maritime law defines relationships between individuals. Until the next time, safe safely.